Lawsuits are not just for delays. Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and Washington, D.C. In this video, we're talking about the fact that an immigrant can sue USCIS when they make a clear error that is contrary to the law or contrary to the facts of the situation presented. We have filed many of these lawsuits challenging the wrongful denial, mostly of green card cases, but also of naturalization cases in federal court, in which we're asking a judge to reverse the decision because it's contrary to the law, it's arbitrary, it's capricious, and the USCIS has made a big mistake. So you can't file a lawsuit like this when it's something discretionary. That is where it's up to the agency to decide, is this a real marriage or not? Do I believe this marriage? Those kinds of things are up to the government and specifically USCIS officers to make that determination. They have to balance the evidence and they can make a decision. Those are not the kinds of cases that I'm talking about. What I'm talking about are situations in which USCIS makes a clear error. Let me give you some examples. Number one, USCIS says, well, you left the United States without advance parole, but in fact, you've never left the United States. They made a factual error. For some reason, their record showed that you left the United States before you received advance parole, and that never happened. That's a good lawsuit. Or USCIS says you did not show up for your interview, and you demonstrate that that interview notice went to your old address and that you have proof that USCIS was notified by you through the timely filing of an AR-11. You notified USCIS of your proper address. So it can't be things that are very close to call or up to the agency's discretion. But if it's something that it's a clear mistake, a misstatement of fact, another one, they say, we sent you a request for evidence, it was sent to your address, you had 87 days to reply, but you never replied. Therefore, your case was denied. If these kinds of things happen, if you get these denials out of the clear blue sky that are wrong on the facts or wrong on the law, Congress has said that you can bring an action in federal court and ask a judge for what's called judicial review. The judge can take a look at the case and she can say, this is wrong. USCIS made a mistake. These are the best kinds of cases to file lawsuits on. USCIS doesn't want a judge to declare that they made a mistake, and they don't want to have to pay your attorney's fees. So whenever we file one of these lawsuits, it always includes a claim under the Equal Access to Justice Act. Now, typically, we're not going to go after those fees unless USCIS really puts us through our paces and really continues to fight dumbly. What we're trying to do when we file these lawsuits for an arbitrary and capricious denial, for an incorrect denial by the agency, is to just get someone's attention. And when we sue, we're suing the agency. Their lawyers find out about it. The supervisors find out about it. The U.S. attorney has to defend it, so they find out about it. Even the judge finds out about it. Well, USCIS doesn't want everybody looking at their dumb mistakes. So when we find a situation where there's been a really dumb mistake, those are great lawsuits. Those are a lot of fun, and usually we get reversals much faster than people who decide to file a motion to reopen or reconsider, an I-290B motion. The problem with I-290B motions is they can take a year, and you're not going to get much higher level analysis than you do when you originally filed. So if you want to get the top of the ladder people to look at your case to figure out, Jesus Christ, these guys made a really big mistake, and you want it done quickly and reversed quickly, and to get that benefit that you are clearly entitled to, the way that you do that is you file one of these lawsuits. Every now and then we even threaten to file the lawsuits, and we've been able to get good action on those. We just had that for a client who USCIS said, hey, you left the United States without permission. You didn't have advance parole. Well, they had applied for advance parole, but guess what? They had never left the United States. And these clowns denied it without any notice of intent to deny, without any kind of opportunity to respond to the allegations that their case was one subject to denial because of this alleged travel. And so when we threatened the lawsuit, that was enough to get the case reversed and to get our client the green card that they so richly deserve. So if you find yourself in a situation where USCIS, not the State Department, but USCIS has made a clear error of fact or of applying the law to your situation, something that's just completely dumb, completely from left field, or something that a regular person with moderate intelligence would say, yeah, that was a mistake. they notified them of the address change and they still got a denial, that's the perfect kind of lawsuit case, and that's what you should be thinking about. So if you want to sue the government because they wrongfully denied your green card or your citizenship and you want our help, give us a call, 314-961-8200, or email us info@hackingimmigrationlaw.com. You can, if you're just looking for free information, I have an immigration answer show that I do on YouTube and Facebook 3 or 4 times a week. You can subscribe to us on YouTube or join our Immigrant Home Facebook group. You'll get alerted when we go live. You can also text the word show to 314-470-3300 to get the link to our waiting room. We also are on TikTok at Immigration Hacking. You can find us there, and we'd love to help you out. Thanks so much, and we'll see you on the next video.